Good morning. Welcome to today's meeting of the Assembly Committee on Government Affairs for the 2025 legislative session. Will the Secretary please call the roll?
Assembly members Carter. DeLong.
Present.
De Silva.
Here.
Edgeworth.
Present.
Flanagan. Gallant. Golding.
Here.
Gurr.
Here.
Hunt.
Here.
Jackson. Karras.
Present.
Kasama.
Here.
Nguyen. Chair Considine.
I am here. We have a quorum, but please record Assembly members Flanagan, Gallant, Nguyen, and Jackson present when they arrive. Welcome to the audience here in Carson City, those joining by video conference in Las Vegas, and anyone listening over the internet. I would like to begin with some housekeeping measures. First, please check and silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide a business card to our committee secretary. When you are testifying, please turn the microphone on and clearly state your name and any affiliation for the record. If you are providing handouts, please ensure that hard copies are available for members of the public. Electronic copies should have been submitted to our committee manager by 9 a.m. on Friday for our committee members. We do expect courtesy and respect in our interactions during the meeting, even if we disagree with someone else's position. And as always, I encourage committee members to ask questions and engage with the material presented. If you have any follow-up questions, please flag them for me so that we can ensure we balance our time effectively during the meetings. And committee members will be using their laptops to view handouts and documents, and please don't interpret that as a sign of disrespect or inattention. Today, we will hear two bills. We'll begin with Senate Bill 210, which revises provisions relating to fees collected by constable and sheriffs for certain services. And then we will hear SB 447, which revises provisions relating to public works. Well, let's get started. I will now open the hearing on SB 210. To present this measure, we have Senator Stone. Welcome to Assembly Government Affairs, and please go ahead whenever you are ready.
Good morning, and thank you, Chair Considine and members of the committee. I'm Jeff Stone, and I represent Senate District 20 from Mesquite, including Henderson south to Laughlin. It is my pleasure to present SB 210, which revises provisions related to law enforcement for certain services. With me today in Las Vegas is Constable Kenny Taylor, constable serving in Henderson. Senate Bill 210 aims to revise the fee structure for services provided by law enforcement agencies, sheriffs of each county in the state of Nevada, and constables. The bill proposes increases in various fees associated with law enforcement services, such as serving summons, taking bonds, and executing writs. The increased fees are outlined on page 2 through 6 of the bill. These fees have not been raised in 20 years. Section 1 NRS 248-275 subsection 1 indicates the fees that a sheriff of each county in the state may charge and collect. Section 2 NRS 258-125 Section 1 indicates the fees that constables are entitled for their services. There is no fiscal effect on local government or the state. The intent is to update the fee structure to reflect current costs, service costs, and ensure that law enforcement agencies are adequately compensated for their services. I will now turn it over to Constable Kenny Taylor, who is appearing in Las Vegas.
Good morning, Madam Chair, Committee, and Senator Stone. I appreciate this opportunity to speak to you on behalf of this bill to increase the fees of the Constable's Office. Here are some of the reasons the fees need to be raised in order to keep up with the current market and inflation. As you had just heard from Senator Stone, these haven't been raised since 2002. The Constable's Office is not a tax-funded office. It's actually funded by the fees that are collected and generated through our offices. The fees, as I had stated, had not been increased since 2002, and inflation has nearly doubled during that time. The cost of doing business has gone up every year since 2002, especially for office supplies, paper, and things like that. Plus the costs of salaries that continue to increase each year. And as the office have grown, there's additional positions that are needed, and those increase the fees as well, or the costs. The cost of fuel alone has gone up from an average of $1.44 in 2002 to $3.15 currently. The cost of the vehicle insurance, which we were caught off guard with in 2024, went up 300%. which was something that clearly was not in the budget, because normally from 2019 on, it had only gone up maybe a few $100s a year. It had never had such a drastic charge to where, or change where our fees alone, just for my office, went from a little over $7,000 to over $28,000 a year just for vehicle insurance. These are the reasons that we are asking you to raise these fees. And just the increase will help us to operate our offices more efficiently. That's pretty much all that I have to say on this matter. Thank you for your time and consideration, and hope that you will pass this bill. I would be happy to answer any questions you may have.
Thank you, Madam Chair. We're happy to answer any questions that you might have.
Thank you, and thank you both for the presentation. We do have a couple of questions from our committee, and we will begin with Assemblymember Goulding.
Morning. Thank you, Chair. Thank you for the presentation.
Yes.
I'm wondering if you could explain how you came up with the new fees. There's not a consistent percentage across all of them. Some of them have no increase, some have huge increases. Can you explain how you came up with the new fees?
Well, I'll let Constable also answer the question, but I met with Las Vegas Metropolitan Police Department representatives, and we talked about the cost of the fees, and they did their own study or evaluation to find out what the cost of doing business was for each of the services they were provided, and they're the ones that made the recommendation for those fees. Yes.
Thank you. Our next question is from Assemblymember De Silva.
Thank you, Chair, and thank you for the presentation. Just a quick question. So the unserved papers, can you explain exactly what that is and how that works? It's a $20 to $30 fee per mile.
Yeah. Constable?
Good morning, Chair Considine. This is Constable Jordan Ross, Chair of the Southern Nevada Rural Constable Alliance and the Nevada State Director for the National Constables and Marshals Association. To answer that specific question, it is not uncommon due to outdated information provided to us by the client that we are unable to effect service. And of course, there are many times in which we need to repeatedly effect based on the needs and expectations of the client. What the provision there in statute that exists now, we're just asking for an increase in that ceiling, is regardless of how much we is spent in mileage and whatnot in trying to effect service, if it's unsuccessful, each attempt currently under the law, we cannot charge more than $20, regardless of how much time, effort, and mileage was put in. So this is asking for an increase reflective very much, particularly, most of that is almost all mileage. And that's why we're asking for an increase in that particular item there. All of these prices, if Chair Considine, with your permission, the earlier question regarding the uneven, or what appear to be uneven increases, the existing statute really doesn't make a great deal of sense. It's been patchwork over decades, and what we're bringing is a little bit more clarity. So $26 for primary service and $3 for certain smaller ones. But the idea was that most of these particular types of work orders take about the same amount of labor, whether it's in the office on the part of clerks or in the field on the part of deputy constables. And this was worked out with my office in Metro about a year and a half ago. Thank you, ma'am.
Thank you. Just as a follow-up to that, so I know some of these aren't stacked, but how many of these fees are stacked? In other words, there's a fee for the form of service, there's a fee for the mileage. How often are these stacked on top of each other?
Mileage is charged in almost all cases where actual travel is involved. So for example, typically on the service of writs of garnishment that are out of state, those are sent by certified mail and there's no charge for that. The mileage, and particularly, of course, Clark County is rather large. and there's a considerable amount of miles that are going to be put on. That'll be charged just simply on a as occurs basis, depending on where the location is. If it's close to downtown Las Vegas, the mileage is not going to be that high. But generally, if it's necessary for someone to leave their office and go out into the field to effect service, there's going to be mileage. If it can be done without leaving, then there won't be.
Thank you. And if you would please state your name for the record.
Yes, ma'am, I apologize. For the record, Jordan Ross, Constable of Laughlin.
Thank you. And I just have one other question. So all of these fees, I understand that these fees are how the constable office is run, but do all of these fees go to one account, or where exactly do all of these fees actually go when they're paid?
Yes, ma'am, for the record, Jordan Ross. It depends on which office. In the urban constabularies, they go into an enterprise fund. In the rural constabularies, they'll go into an operating fund that the constable is personally responsible and liable for. So for example, in a rural office, if payday rolls around and there's not enough money, this happened last week and 3 pay periods ago. We didn't have adequate money for payroll, so I just didn't get paid. And so that's pretty much how that works. It's a little different in the urban. So the fees go into enterprise funds that are carefully regulated by the Clark County Audit Department. In Mineral County, I'm not specifically aware how that's done, but the fees go into the county treasury there. The rural constabularies, where the constables are typically paid a flat annual salary of $1,750 per year, they are then responsible for managing their own revenues.
Thank you so much for that question. Committee members, are there any other questions? Seeing none, thank you so much for the presentation. We will now move on to testimony. Testimony can be provided here in person in Carson City via video conference in Las Vegas or over the phone, and further instructions for providing that testimony can be found on the agenda. First, we will begin with testimony here in Carson City in support of Senate Bill 210. Please go ahead when you're ready. You have up to 2 minutes.
Thank you, Chair Considine and members of the committee. My name is Jeff Rogan, Jeffrogan, and I represent Clark County. As you heard from the constables, there is a need for this. These fees haven't been raised in 20 years. And what that means is that the county is subsidizing a lot of work that these constables are doing. This also applies to the deputy sheriffs and a lot of other counties who are performing these services that constables generally do in Clark County. But in Clark County, at least, we're spending $1.2 million a year of taxpayer money to support the constables' offices. And just for reference, most of the time what these constables are doing are enforcing private judgments. Those are lawsuits between private parties. And so we're spending taxpayer dollars to help private parties collect those judgments. And that's not an appropriate use of taxpayer dollars. So this fee increase will offset that and help reduce or eliminate the subsidy that Clark County is providing.
Good morning, Chair Considine, members of the Assembly Government Affairs Committee. My name is Chris Reese. It's R-I-E-S. I represent the Las Vegas Metropolitan Police Department. I would just like to echo my esteemed colleague from Clark County, Jeff Rogan's comments, and that Metro supports SB 210. Thank you.
Thank you. Not seeing anyone else in Clark County step forward to the table, we'll move to Las Vegas. Is there anyone else in Las Vegas wishing to testify in support of SB 210? Seeing no one else approach except the 2 presenters already at the table, AVH will go to you on the phone lines. Is there anyone wishing to provide support testimony for SB 210?
Thank you, Chair. The public line is open and working. We have no callers for support of SB 210.
Thank you. We will then move on to opposition. Is there anyone here in Carson City wishing to testify in opposition to SB 210? Seeing no one move towards the table and seeing no one else in Las Vegas, AVH, we're back to you for testimony in opposition of SB 210.
Thank you, Chair. The public line is open and working. We have no callers for opposition.
Okay, then we'll move to neutral. Is there anyone here in Carson City wishing to testify neutral on SB 210? Seeing no movement in the room and seeing no other people in Las Vegas, Aviator, back to you for neutral testimony on SB 210.
Public line is open and working. We have no callers for neutral at this time.
Thank you. Would the presenter like to come up and make any final remarks?
Thank you, Madam Chair. I just want to thank you for the consideration. Senator Orenshaw and I urge you to support this bill. Thank you very much.
Thank you. And I will now close the hearing on Senate Bill 210, and I will open the hearing on Senate Bill 447, which revises provisions relating to public works. To present this measure, we have Andy Donahue with Southern Nevada Laborers, Employers Cooperation and Education Trust. Please go ahead whenever you're ready.
Good morning, Chair Considine. Andy Donahue for the record. Senator Flores does intend to join us, and he's en route, so we'll keep a chair open for him in the meantime. I'll begin with the prepared remarks, and if there are any questions, maybe he'll be here just in time to add a little bit to that, if that's all right.
Would you like us to take a 2-minute recess, or would you like to move forward?
I'll begin with the remarks, and hopefully that will give him plenty of time to join us.
All right.
Thank you, Chair Considine. I'd like to begin by elucidating that this bill is dedicated to maintaining equal justice under the law and growing competitive marketplaces. Legally sound public works administration ensures safety on the job site and the well-being of all taxpayers. Currently, reasonable costs can already be recovered to enforce contracts under NRS 338. When that happens, a court or arbitrator shall award reasonable costs to prevailing party. This adds a second type of case to that short list, specifically cases that result in judges telling the government to follow the law, also known as writs of mandamus. Judicial discretion is the cornerstone of this policy, allowing for case-by-case review based on evidence, such as documentation provided from each party. Even when a judge tells a government entity or public actor to follow the law, this bill does not automatically require reasonable costs to be paid to anyone. Few situations considered in this bill would be an individual who would not be paid correctly because of an administrative error. That individual could bring action, win, get all the back to pay, only to then still be at a detrimental deficit when the cost of speaking up is paid from what he or she already earned through an honest day's work. A similar situation could impact a small business owner, a job creator, because when administrative errors violate the law, it can deprive an entire industry of even having the opportunity to compete. Such as if a construction project is administered as maintenance instead of construction. When that happens, construction workers don't go to work, and business owners cannot make a competitive bid. More competition grows industries and benefits taxpayers. Chair Constant, I'd like to provide a timeline of all the steps that would have to be followed for a judge to consider what we're talking about today. First of all, there would need to be a mistake by an awarding body. That mistake would have to go uncorrected. A court would have to be asked to correct the mistake by issuing a writ of mandamus. The court would consider at least two matters. First is standing. Is the party asking for help directly and substantially affected by the mistake? And is the law they're relying on meant to protect people like them? That's standing. Second, the judge would have to decide whether the government should follow the law and correct the mistake. Both of those would have to be answered yes, and each step before that would have to occur for the court to then consider what it would take to make a party whole who was set back. So no damages, no profits, at most reimbursement with sound public administration and participation. Reasonable costs for successful writs of mandamus are not a new concept. The Equal Just Access to Justice Act from the 1980s has allowed courts to consider this. The bill today solidifies that for writs concerning public works law, that they should also be worthy of a judge's full consideration. This bill is a narrowly tailored solution that promotes accountability, compels administrative and bureaucratic compliance, continuing on, and helps ensure fair treatment of workers and job creators alike who are paid with tax dollars. Thank you, Chair Considine.
Thank you. Would you like us to move forward with questions in the committee, or would you like us to hold?
I'll give the questions a try.
Okay.
Andy, for the record.
Committee members, do we have any questions? Yes, Assemblymember DeLong.
Thank you, Chair. Thank you for a very brief presentation. I have a couple of questions that are related. First is, in Chapter 34 of the NRS, there's already a provision to get a writ of mandamus issued. Why do we need to put it in another chapter of NRS?
Judges, Andy, for the record, also in that chapter, judges need a clear contract provision, a clear rule, or a clear statute to even consider the financial implications of speaking up. And this would create the statute condition to enable judges to have that liberty in their own courtroom. Thanks for the question. So we're not creating the ability to bring a writ, that is already there. It's when this happens, judges need something very specific, such as this bill, to consider what kind of setback the whistleblower or petitioner was under to correct this mistake. That's what we're doing here.
Thank you. So you're basically looking at trying to allow the collection of attorney's fees and maybe any other associated costs. I'm assuming other than wage issues, because wage issues can be addressed differently, separately through the Department of Labor. So I'm assuming you're thinking about court costs and getting attorneys paid.
Andy, for the record, for individuals that need to advocate for themselves, the idea of them being out of pocket to correct another person's mistake is what brought this bill. And those costs that you articulated are an unfortunate part of doing that in some cases. So yes, that is part of what we're talking about today.
Thank you. Thank you, Chair.
Thank you. Our next question is from Assemblymember Flanagan.
Thank you, Madam Chair. Thank you for the presentation. I just want to try to understand, so is this for like small contractors? Is this large contractors? It's like if a person, say, is a plumbing contractor or something, and they do a job and something doesn't go well. I'm just trying to understand how it comes to happen. Can you help me with that in whatever way you can?
Sure, Andy, for the record, thanks for the question. That first and foremost, in my mind, sounds like a contract dispute, which there are provisions in public works law for. This would be more even before the job commences. If that contractor, in your example, is unduly excluded from the opportunity to even make a bid for that project because of a mistake by the awarding body, this bill would help that contractor or plumber to make sure the process is fair, for his best effort to be put forward and considered, and then earn the job on its merits. So it's more on the front end than the back end in the example.
Chair, quickly?
Yes.
So this is like when a company or agency, because the government agencies often put out requests for bids from different companies. This is at that point if something doesn't happen properly in how it's posted to allow them to participate. They have some recourse of action because they were excluded.
Andy, for the record, that is correct. I would point to a statutory waiver by public agencies to call on them to be treated as any other entity under the law. If that contractor had a dispute with a private entity, we wouldn't be considering this provision. It's already there for the most part. I'm not clear on why there should be a government discount on justice when someone has a good point.
Thank you. My questions, actually, there's just the one. In the new language, it says a court may award reasonable attorney's fees. So this is still the court's discretion whether or not to do it at all. Is that correct?
Andy, for the record, that's exactly right. It is a may. Current provisions have a shall in 338 for this type of consideration on the contract dispute section that I referred to earlier. So yes, absolutely correct, Chair Considine. It is a may, putting it squarely in the consideration of the judge on a case-by-case basis based on what the parties have to tell the judge.
Thank you. Members, do we have any other questions? Seeing none, we will move on to testimony. Thank you for the presentation. Again, testimony can be provided here in Carson City in person, via video conference in Las Vegas, or over the phone, with instructions being found on the agenda. We will begin with testimony in support of Senate Bill 447 here in Carson City. Seeing no one approach, not seeing anyone in Las Vegas, we will move to AVH. Is there any testimony in support of SB 447 on the line?
Chair, the public line is open and working. We have no callers for support of SB 447.
Thank you. We will move towards opposition. If you would like to provide any opposition testimony to SB 447 here in Carson City, please come up to the table. Begin when you are ready, and we ask that you keep each additional individual comment to about 2 minutes.
Good morning, Chair Considine, members of the committee. For the record, my name is Jimmy Lau with Ferrari Reader Public Affairs, representing the Nevada Contractors Association in opposition to SB 447. NCA is concerned with the unknown effects of this bill and what appear to be a significant deviation from the typical construction of this type of extraordinary judicial remedy. At the federal level, in the vast majority of states and in Nevada, this type of writ is almost never accompanied with a specific entitlement for a prevailing party to be awarded attorney's fees and costs. Additionally, writs of mandamus are always and will, regardless of the passage of this measure, remain an available remedy under NRS Chapter 34. Thus, establishing this specific judicial authority over NRS Chapter 338 is unnecessary and would create a significant inequity between those pursuing these writs under NRS 338 and persons pursuing these writs under any other non-discretionary duty by a public agency or official in Nevada. Finally, the Nevada Contractors Association opposes any measure that exposes awarding bodies to additional unknown expenditures, which could result in project delays or further reductions in availability of funding for future projects. Writs of mandamus are considered extraordinary for a reason, and chiseling away at that extraordinary positioning is concerning in general, but particularly within the context of NRS 338, which already provides a variety of remedies, some of which were discussed today, for any party with a substantial interest in public works. NCA respectfully requests that the committee oppose this measure. Thank you.
Thank you, Madam Chair, members of the committee. Alexis Motorex with the Nevada Chapter Associated General Contractors, representing commercial construction industry in Northern Nevada. We are here today as well in opposition to SB 447 for the reasons articulated by Mr. Lau. There's a system already in place to challenge violations of NRS 338. This bill would circumvent that process. While admittedly contractors could benefit from this change, my members do not feel it is necessary or worth the potential financial risk to public owners. Every dollar public bodies are spending on legal defense and reimbursing attorney's fees is a dollar not being spent on services or public works projects.
Thank you, Chair, committee members. Isaac Hardy representing the Urban Consortium, which is made up of Reno, Sparks, Henderson, Las Vegas, North Las Vegas. We do have some concerns with SB 447 as amended. NRS Chapter 338 contains important requirements with regard to the performance of public work at the local level, traditionally outlining the costs associated with legal action and other disputes related to the enforcement of Chapter 338 is dealt with as a contractual matter between the local governments and the contractor. The process has historically worked and we see no need to change the process. Putting these kinds of requirements in statute removes flexibility for both the contractor and local governments in dealing with issues as they arise. We respectfully request the tried and true process currently in place be permitted to continue. Thank you.
Good morning, Chair Considine and members of the committee. For the record, Jennifer Berthiaume, that's Berthiaume, Government Affairs Manager at the Nevada Association of Counties, or NACO, whose members represent all 17 counties. I'll echo the comments of my local government colleague, and I also would like to apologize to Senator Flores for not being able to speak to him before coming up in opposition. This bill would impact the way local governments structure contracts with public works contractors and may encourage contractors to seek redress through the courts rather than working with the public entity. Additionally, many government agencies prohibit in their contracts the award of attorney fees and costs as a way to manage legal exposure and protect public funds. Allowing fees regardless of contract language would create uncertainty and discourage early resolution between parties. This version of the bill would override those contracts. For these reasons, NACO is opposed to SB 447. Thank you.
Good morning, Chair Considine and members of the committee. For the record, Kelly McNeil, MCNEIL, Executive Director for the Nevada League of Cities. SB 447 in its current form poses significant challenges to local governments. It poses financial risks and litigation exposure, especially for our smaller cities. This bill reduces discretion and flexibility in how local governments manage disputes. And for these reasons, the Nevada League of Cities is opposed to SB 447. Thank you.
Thank you. Seeing no one else approach to provide opposition testimony for SB 447 here in Carson City, seeing no one in the audience in Las Vegas, AVH, let's get back to you with opposition testimony for SB 447.
Chair, the public line is open and working. We have no callers for opposition.
Thank you. We will then move to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral on SB 447? Seeing no one coming up to the table, still seeing no one in Las Vegas, AVH will go to you for testimony in neutral.
Thank you. The public line is open and working. We have no callers for neutral.
Thank you. Before I call you up for final remarks, since we have the presenter here, if Senator Flores would like to come up and answer a couple of questions before we go to final remarks. Assemblymember Flanagan.
Thank you, Madam Chair. Good morning, Senator Flores. Thank you for being here. Just want to get a sense of, since you're bringing this piece of legislation, if you can give us a sense of how often circumstances occur that would make this a reasonable piece of legislation to put in place. What are we dealing with?
Thank you for that question, Assembly Member. And Madam Chair, through you, Senator Edgar Flores, for the record, proudly representing Senate District 2. I will, in a 2-minute synopsis, just summarize how we got to where we are today. As all of you had an opportunity to do, particularly those of you who were coming back, during the interim, I met with a lot of different stakeholders to understand different issues that were happening in the community that I thought maybe I could potentially assist with. We all do it. We reach out to different stakeholders, nonprofits, constituents, et cetera. In engaging in those different conversations, I had an opportunity to speak with Mr. Donahue specifically, and we engaged in this conversation of a writ of mandamus. And just for the sake of clarity, and I know Mr. Donahue has already made this clear, but a writ of mandamus is just you telling a government actor or a state agency, do your job. That is all a writ of mandamus is doing. We're not going beyond the scope of that. You're saying you're supposed to do something, do it. That is the way a writ of mandamus is utilized. In having a conversation with Mr. Donahue, we were discussing how there was scenarios, and I do agree with you, Assembly Member, that this is not happening every day. So luckily, it's not something that we're going to have to use all of the time. But in those extraordinary circumstances where the work's been completed, and now you're owed $150,000, I'm just using a random hypothetical number, or you're supposed to have a certification issued, and they haven't done it, it's the small business, it's the people that took on this job that are sitting there. They can't pay their workers, they can't pay the business. The opposition that came in today, which is very strange, to be frank, was focused on how this could hurt the business. Not getting paid the money you're all owed is what hurts a business. That's what's creating this nightmare. That's what puts you in a very difficult situation. And then what's more frustrating is that that business has to then go and hire an attorney to compel a government actor to do what they're supposed to do and then lose that money. Now think about that. I am owed $150,000. I have to hire an attorney. I have to put in weeks, maybe a month or more into a court process, add more burden to me as a business. And then on top of that, when I finally get what I'm supposed to be given, I'm on the hook for all that money I just spent. So that's my concern. And I said, well, this is something we can engage ourselves in. And I agree with part of what the opposition mentioned, which is a writ of mandamus is something that's already there. They should already be able to do so. But however, we found out that there are scenarios where the court said, we believe we can't do this because there was a contract and that supersedes it, and we're not sure that we can engage in this activity. So we were concerned about that. So we said, we just want to make it abundantly clear that if you're going to make the business who's on the hook, who's done the work, who's done everything correctly, spend more time in court to just get paid or get whatever they deserve to make them whole, then in that scenario, let's make that company whole by giving them the opportunity to get the attorney fees or whatever they spent and on costs. So that's how we got here. But I do agree with you, Assembly Member, this is not something that's going to be happening every single day, luckily. But in those extraordinary circumstances, we want to make sure that everybody has clear understanding that they are obligated to fulfill their obligations, period.
Andy Donahue, Chair Considine, do you have a question? I'd like to add a statistic to this at this time. Should I do? Okay. Andy, for the record, I would just like to reference some Supreme Court statistics indicating that they resolved 396 writ petitions and intermediate courts resolved approximately 30, and determining how many of them fell into public works is a further screening that we haven't gotten to yet.
Thank you. And just to clarify, so this, and writs mandamus are usually for extraordinary relief, but they're not, they're more often used than I think people think. But for clarity, this would only happen after the work is completed and payment hasn't been given?
Thank you for that question, Madam Chair. Senator Edgar Flores, for the record, not necessarily, because there may be other hypotheticals where you need to have the government actor or agency to take certain actions to allow for certain things to happen. Sometimes a writ mandamus can sometimes be utilized to force a permit or a license to occur. I mean, there's a lot of different scenarios where a writ may be utilized. But in the hypothetical that we were focusing on that actually occurred, it's an actual scenario that was brought to us and we realized, wait a minute, there's a problem here, did involve attorneys having to get involved, did involve forcing the government to do their role and putting, unfortunately, the business in a very uncomfortable position because everything was paralyzed up until that moment.
Thank you very much for for allowing us to, or answering those questions. And so now we will go on to any final remarks.
Madam Chair, again, Senator Edgar Flores, for the record, I appreciate everybody's indulgence. Running between committees, and we have several events going on today. By the way, which, Madam Chair, I have to do this plug. We are also celebrating Tyrone Thompson Day of Mentorship today. There's a bunch of students. Please give a big shout out when you see them roaming our hallways. But one of the things, Madam Chair, that I wanted to just clarify, when we presented this bill in the Senate, we didn't have opposition. And that's not to say that you're not allowed to oppose a bill in the second half of this conversation. But it is to say that at a bare minimum, conversations should have occurred. We had one individual, which we're appreciative of, reach out to Mr. Donahue and nobody else, really, until the eve of this presentation. Now I get how this building works. One person's opposition, you build a coalition, you start bringing people in. I get that, and that's how the building works. But I do just want to have to call that out because that's not how we operate in this building. The bill's been out, it was pre-filed, there was conversations that were had, there was a bill presentation that occurred, there was a whole host of things that happened. So yesterday and a couple of days before, probably not the best time to wait to have this conversation. Respectfully, if anybody would have done that to any one of your bills, you would have some questions. So I'm calling it out because that's inappropriate. With that said, we are willing to work with the opposition. Whatever concerns we can raise, we're comfortable with. But what we're not going to do is tell somebody they can't do a writ of mandamus and that the judge can't take that into consideration. This is an extraordinary form of relief that when you have to compel the government to do their job, you should have this available to you. And a judge should not feel that they can't give you the opportunity to engage in that. And if you're going to make me spend money and you're going to make me spend weeks or months doing this, then I should be made whole. And so with that, I am open to working with any one of the members of the committee, and I'm also open to working with the opposition to understand some of their concerns. But again, we are just trying to make companies whole. Thank you, Madam Chair, and thank you again to the committee members for allowing us to present this bill.
Thank you. I will now close the hearing on Senate Bill 447 and move to the last item on our agenda, which is public comment. Public comment is not an opportunity to rehear testimony on a bill, and we ask that you please keep your public comment to topics within the jurisdiction of this committee. As a reminder, members of the public can provide public comment in person or telephonically and may submit public comment up to 24 hours after the meeting. Instructions for providing public comment can be found on the agenda. You can call in for public comment today, dialing 888-475-4499. When prompted to provide the meeting ID, enter 811-4541-5570, and then press pound when prompted for a participant ID. Each person will have 2 minutes to provide testimony, and please remember to clearly state and spell your name for the record. Is there anyone here in Carson City wishing to provide public comment? Seeing no one in Las Vegas. AVH, is there anyone on the line for public comment today?
Thank you, Chair. The line is open and working. We have no callers for public comment at this time.
Thank you. Our next meeting will be Tuesday, May 6th at 8 a.m. in room 4100. That concludes our meeting for today. The meeting is adjourned.